The matter before the court is Oxford 2444, James Day versus the Town of Hiram et al. We are being streamed live on the web by audio and by visual. And I would ask counsel who are arguing to introduce yourselves by saying your names for the record, together with the party you represent, starting with the appellant.
Sean Turley for the appellant, James Michael Day.
David Goldman for appellees Brian and Sarah Schnell.
Okay. And the town is not separately arguing, I take it?
Correct.
Okay, thank you. Then, Mr. Turley, if you're ready to proceed, we'd be happy to hear your argument.
Your Honor. Good morning, Your Honors. May it please the court. This case is an appeal by my client, James Michael Day, of a decision by the Planning Board for appellee Town of Hiram to issue a conditional use permit to appellees Sarah and Brian Schnell to construct and operate a brewery and beer garden on land they have leased in a residential district in the town. There are two independent grounds for this appeal. The first is that the board committed an error of law when it misinterpreted the so-called necessity standard, which I'll get to in a moment, and that there's no competent evidence to support the finding on that standard. I will focus my introductory remarks on the first of these grounds for the appeal. So I'd like to start with the text of the necessity standard itself. Under the necessity standard, applicants for conditional use permits are required to show, quote, the need of a particular location for the proposed use. It is my client's position that the necessity standard means what it says. In order to satisfy it, an applicant needs to show that something is needed about the particular location proposed for the use in order to conduct that use. Notably, the necessity standard does not say the applicants need to show the need of the particular location for the applicant. The emphasis here is on the need associated with the use of the land, not the needs of the user of the land. Despite this, the board found that the Snells complied with the necessity standard by first finding that the proposed brewery was located, or rather they had a property interest in land in the residential district where they hoped to have a brewery, and presuming that the Snells did not actually have a property interest in any other land in the town, including the commercial district. In essence, they transformed the necessity standard into a test of whether or not it was really convenient for the Snells to conduct the brewery on land they already had an interest in, and in a sense a financial capacity test about whether or not they could afford to relocate or put the brewery in the commercial district. The cardinal rule of ordinance construction the court should apply here is that ordinance provisions should be read according to their plain and ordinary meaning. The plain meaning of the necessity standard really hinges on what the word need means. The word is not defined in the ordinance, but necessity is. And it says the necessity exists when one thing, quote, cannot be done without something else. In the same vein, one of the stated purposes for the residential district where the brewery would be located is that commercial uses are not allowed unless they're, quote, compatible with and necessary to residential development. I appreciate that people enjoy breweries. I think it would be a stretch to say that they're necessary for residential development. Looking through the dictionary, necessary, which is synonymous with need, generally means something that's essential or indispensable. This court has defined essential to mean, quote, indispensable, absolutely requisite, and indispensably necessary. This idea that need implies...
Counsel, I see that the green light is on.
Yes, Your Honor.
And can I back you up a little bit then?
Absolutely.
You have posited that a failure to meet the necessity standard, as you have defined it, means it requires the board to deny the application. Is
Correct,
that
Your Honor.
correct? Well, I'm looking at the ordinance, and I don't see anything in the ordinance that says, unless you find that they meet each and every factor we have listed, the application must be denied. To the contrary, it simply says, in subsection 1 of 6.7.3.4, in considering a conditional use permit, the board shall evaluate the effects of the following things. And then in subsection 2, it says the planning board shall also consider the following factors. And I'm going to suggest to you that certainly in our jurisprudence, when we list a number of factors, it doesn't mean you have to necessarily attain every single factor. It means on balance, in consideration of all of these factors, it meets whatever the standard is, whether you're talking about, are you in custody? Is it voluntary? Is it, the issuance of even an injunction? I mean, you're weighing if one factor is particularly strong and in favor, or if one factor is particularly against. So why are you suggesting, regardless of how we define it, putting aside that
Yes,
issue,
Your Honor.
that a failure to meet the need standard means it's fatal?
Sure. So two reasons. One is you have the use of the word shall in this provision, as you do in the preceding provision. I do think those need to be read together as listing a variety of factors that shall be considered by the board. I would suggest that tasking or authorizing a board to consider factors, but to no end, would render those factors fairly superfluous.
Well, the end be whether it's appropriate or other conditions. It talks below about that upon consideration of the factors, the board may attach such conditions in addition to those required elsewhere that it finds necessary to further the purpose, et cetera. I mean, it doesn't, there are reasons for considering it.
Sure, Your Honor. I take your point. I would say that certainly if the intent here was to create some type of, as you put it, a balancing test of sorts of, I'll consider all these factors and in the totality, this is not too harmful to locate in the residential district. I think the ordinance text itself would reflect that balancing. I think the way that they're listed.
Or if it thought that it was going to be sole grounds for excluding an application or for denying an application, it might say that shall be denied.
Well,
if it doesn't
again,
meet.
I would read the prefatory language in the preceding section with the consideration section to be in a basket of things that must be satisfied. I agree that part of how they're used is to consider what conditions might be attached and whether or not the conditions are sufficient to mitigate any harms, but I don't think that's the sole way you look at them.
If you look at these as precatory, then you could come up with some odd results, like C is access to the site. So the board could say, there's no access, but so what, if all they have to do is consider it. And I'm not thinking that's the intent, but backing up.
Sure.
First, we have to figure out whether they use the right test. And you're saying they use the wrong test, that need has to focus on the need of the property, the need of the location. So then we get to, say you're right, then we have to get into what does need mean. And the case law on that is very, it varies from place to place, but the general trend is to say, in this context, need means more like in the public interest, like a certificate of public convenience and necessity. It doesn't mean absolutely critical.
Your Honor, I'll concede that I don't think, and it has never been my client's position that in order to obtain the conditional use permit, they'd have to show that there's literally no property anywhere else in the universe where they conduct this use. I think
Well, you
they have to
did
show,
say indispensable. That's your word.
that's the court's definition of essential, which is part of the definition of necessary. I think, as I said, it's a relationship of indispensability. I think they had to show something. And here there's an absence of any showing of any kind. And they could have a variety of things. I mean, obviously the most obvious examples are one where the land use itself requires something geographically in the land itself, like a gravel pit or something. But they don't show anything to that effect of there's a need, even in terms of kind of just a brewery in itself, like what the inputs are. There's no showing at all. So I think it oversells the kind of indispensability of sorts, and I'm in part taking into account, Justice Connors, what you're saying, that need is not, I don't think it in every situation, in every context, means absolutely requisite.
Well, we have to, assuming they use the wrong test, then we would need to remand it because they make the decision.
Sure.
But then we'd have to kind of give them a little help on what this means. And the definition of need can't be too squishy because then you get into an excessive delegation problem. So we need to have some specific, this is what it means. Does it, and there's the gamut of indispensability, and then there's need that just says, well, the community, if there's no grocery store in that community, that would be good enough. Or if the only thing you can do on that property is this particular use. But don't we have to give some kind of specificity in order to avoid that constitutional problem?
Sure, Your Honor. I think absolutely this court can aid not only Town of Hiram Planning Board, but any other municipality that has this need language in articulating what need means. I do think, though, that when dealing with ordinance construction, you're dealing with kind of the ordinance as a whole, which is one of the key kind of canons of construction. And I do think that the definition of necessity and that statement of purpose regarding basically that a commercial use needs to be necessary to residential development pushes things closer on that spectrum, as you identified, towards indispensability and away from just kind of like, you know, a want or it's convenient or, you know, the public would be benefited by. So I think
Let me take you back to the question of remedy here. Even if you're correct that the planning board used the wrong standard by looking at need from the applicant's standpoint, and even if you're correct that there is no evidence to support a finding of need here, this is one of 11 factors in subsection 2, and if you add the 5 factors in subsection 1, it's 16. At best, if you're correct on all of your points, that gets you a remand, doesn't it?
Your Honor, I believe it would get me a remand. So if the court determines it's an error of law in terms of that interpretation of the necessity
Right.
standard, it'd be a remand to vacate the issuance permit. Of course, and this is always the case in the ADB context, resources, in terms of if there's resources available, an applicant can always reapply and seek a different permit, and then make the showing as articulated by this
Well,
court.
but
of
is
what
it a
need is.
vacate or is it a remand to reconsider the existing evidence in light of, or even arguably take new evidence in light of the definition that we supply?
Sure, Your Honor. I think over several cases, this court, when faced with an error of law, has vacated the underlying decision, has not remanded for additional findings, except for in cases where maybe
Well,
there was some inadequacy of a record.
I understand we vacate the decision, but you've posited that we not only have to vacate the decision, but they would have to start the process anew. And a lot of times when a decision is vacated, it still simply goes back to the planning board. We're vacating on the decision that was made, but it doesn't mean you have to start the process anew.
Sure, Your Honor, but under the law, if a municipal tribunal issues a permit and they didn't have the legal authority to do it, or they violated the ordinance in doing it, that permit is void.
But
So-
that would only be if we said, as a matter of law, there is no evidence, correct?
Well, no, that if you find that it was an error of law in terms of their interpretation of the ordinance, that's what I'm suggesting requires vacating. I also independently think if the court made clear in Fismer v. Cape Elizabeth that in a sense, a decision not supported by competent evidence is, quote, erroneous as a matter of law.
I just want to make sure I understand your position.
Sure.
If we sent it back and the board said, there's no need, does that kill the whole project, or is that just a factor they considered and didn't weigh in favor of the proposal?
I don't fully understand your question, Your
Okay.
Honor.
Let's say we remanded back with the definition, you have to look into the need of the particular location for proposed use. And they look at it and say, there's no need for a microbrewery here, period. Does that kill the project? Do they have to reject the permit?
I think they would. I mean, I think.
Okay, I just wanted to be clear in how far down your argument you're going.
Absolutely. Your
Thank
Honor.
you.
Thank you.
And Mr. Goldman.
May it please the court, my name is David Goldman, and I represent the appellees Brian and Sarah Schnell, who were granted the conditional use permit that's at issue in this appeal. This case involves at its core a neighboring landowner who doesn't like that any use whatsoever is being made of his neighbor's property, and when searching for any part of the conditional use permit provisions of the town's ordinance that he could imaginatively interpret in a way that would, in his view, thwart the Schnell's efforts to open this small business, a small microbrewery, on their property. After the town's planning board rejected Mr. Day's challenges to the Schnell's ability to satisfy, as was pointed out here, the 16 factors applicable under the ordinance to deciding whether to grant the conditional use permit, Day was reduced to arguing in court regarding only 2 of those factors, and now we're left with 1. And it's just important to understand that that 1 is not being argued about today because it, in the context of the ordinance, is extremely important. It's just that that is the only one that a good faith argument could be made
I
against.
see that the green light is
Sure.
on. So I really have two questions. One is to follow up on what I was asking before. Is it your position that the factors as listed have to each independently be met in full, and the failure to do so is fatal? Or is it more a weighing? Maybe there's not such a strong need, but it meets all the others, or something like that?
Right. I think it's a very good point that one of the things that distinguishes a factor from an element is the idea that all elements need to be met, whereas factors are things to be considered and weighed. And I guess the way I view it in my mind is it would be a little bit like some of the statements that have been made about the standard for being granted a preliminary injunction, for instance, where if a stronger showing is made on one, maybe a weaker showing is necessary on the other. I'm not sure that any of that really matters in the context of this particular appeal, because even if you take that the Schnells need to satisfy each and every single one of these.
Well, it may matter, though, because if we define need as in more strong terms, it's hard to see how, as much as I might like one, there's ever actually a need for a microbrewery.
Well, that all depends on which perspective you view it from, right? I mean, the core of Mr. Day's argument has been this plain language argument. But when you actually look at the language closely, and it says, the need of the location for the proposed.
It doesn't say the need of the owner. It doesn't say the need of the proponent. It says the need of the location.
Right.
I'm not sure how the need of this location, whether it's defined as your client's property alone or a larger location or community.
Mm-hmm.
It doesn't say the need of your clients.
Well,
it says the need of the location.
Well, there's two answers to that. One is that the most plain reading of that would be actually, does this physical piece of land need a brew pub or anything else, which is so absurd as a concept that it should be thrown out as a possible interpretation of that. And so if you're going to that's what the plain language means. If you're going to throw out that most obvious plain language reading, you got to resort to all kinds of
No, not
construction.
necessarily. I mean, the location can mean this area of the town.
As
This area
opposed
of
to
the
site,
town
which is
doesn't
what's
have a
used.
gas station.
Yeah.
So we need to have a gas station there.
Right. Well, but then you get into what does need mean, right? And
Correct.
so
That's
need.
why we're here.
So if we're going to talk about what need means, if I say to my wife, I need to stop at the store to pick up some milk on the way home because we're running out of milk, it does not mean that if I don't do that, it's indispensable to our lives or indispensable to the universe. What it really means is it's convenient.
Well, and it's not really a yes or no. It's really a scale, isn't it? I mean, or a continuum.
Right. And so, does the town need some sort of a brew pub in this location? I don't know, but the bottom line is that it's human beings who are applying for this, permit. So the idea that it doesn't say, does the applicant need, the entire analysis is from the perspective of what the applicant has put before
But the use
planning board.
runs with the land. Let me give you a hypothetical, okay? There are 15 breweries in the commercial district, and someone gets a permit in the residential district on the basis, like here, they don't own any other property in the commercial district, so they really need to use this particular piece of property for their brewery. The day after he gets the permit, big brewery company who owns half the land in the commercial district and 10 of those breweries buys that piece of property. They get the brewery. They had absolutely no need from their individual perspective. Does that sound right to you?
Well, you're actually positing exactly the kind of interpretation for where someone might be denied a permit that both the code enforcement officer and we recognize are possible, and the town and the planning board recognize is possible. If you're a landowner who owns property in a residential district and owns property in a commercial district, you might not need your property in the residential district to do the commercial use you want to do, but here the showing was that they don't own the property anywhere else, but they don't have
They
rights.
don't, but tomorrow they sell it to somebody who does. Now, does that sound right as a matter of zoning and land use?
Well, you you can posit what might happen in the future. That's purely hypothetical.
Well, we're trying to figure out how to interpret what this means. I mean, and it has to make sense, right?
Sure.
Because it has to do with the regulation of the land.
Sure. And I just think it's important to understand that the entire ordinance itself is a little bit squishy and vague, to the point that, as we pointed out in our brief, there's this case from 40 years ago, Chandler versus Town of Pittsfield, in which identical language to what we're talking about here got ruled as so vague that it couldn't be enforceable. And so that's why I think you need to take a step back and just, instead of trying to imagine what might happen in the future, apply the canons of construction for statutory interpretation to what we're presented with here.
Well, I'm trying to apply it, and I really don't see how you make the leap that the need of a particular location, and we could talk about what location, how we interpret that, but how the need of a particular location translates into the need of the owner of the location.
Well, and that there you got to look at there are conditional,
or whatever, but.
Right. There are two different kinds of commercial uses under the ordinance that you can get conditional use permits for in a residential district. One of them are these small businesses, which I guess to a certain extent addresses the concern that some huge consortium is going to be operating some huge commercial concern down the line, where it's got to be 2,500 feet or less, 4 to 6 employees at most, I think it was. But the other kind of conditional use that's allowed in residential districts are ones specifically tied to the land, the forest or farm location uses. And so it goes to show that the drafters of the ordinance understood when they want to tie this to something particular about the land, that's how they do it.
Well, when they feel like they want to identify what uses are allowed within the land, generally they zone. They say, you can have these as you don't need anything. But if you want to get a conditional or special exception, then you have to show more. And so what you're saying makes perfect sense when you're getting the comprehensive plan together and you're deciding what uses are allowed within each district. But that's not this situation.
Right, and all I'm saying is that beyond the comprehensive plan, the drafters of this ordinance specifically identified that forest and farm uses, which are uses that require that the land in particular, those are identified as a separate kind of conditional use that's allowed. There's that kind, and there's small businesses, the small physically and small in terms of the number of employees. And the judgment is being made, essentially the concern of zoning ordinances is what effect is my use of my property that I want to make going to be on your property. And so the judgment is being made that small businesses that are physically small and that have few employees are not likely to have a very big impact on surrounding uses.
Well, you're saying it sounds like it's compatible, so it's close enough. But that's not what the language of this, it's not a compatibility provision, it says need.
Right, the need, but then, and again, so the need, I think all of these need to be viewed from the perspective of the applicant is applying, and does the applicant have a
Why
need?
can't need be viewed from the applicant and the town and the community? Why do we have to adopt a linear or restricted view of need?
I think that is a good point, that we don't need to decide every case that might arise under this standard now. All we need to say is that this particular use satisfies the need because the applicants need it, without foreclosing the possibility that the town can also bring in its concerns in the future, or even something specific about the land.
But if the town wanted to tie this to a particular applicant, wouldn't they have said the need of a particular applicant for the proposed use? It says location, doesn't say anything about an applicant. It seems to me the point you're trying to make here, to look at it from the applicant's point of view, that's not what it says. It says the exact opposite.
Well, I think that it doesn't say that you need to look, saying the need of the location for the proposed use does not in and of itself imply to me that we're looking at it from the town's perspective or anyone's perspective. The way you determine, it's fundamentally ambiguous as to what it means.
Well, let me just ask you, if we decided that it is the town's perspective here, whether the need of the town for this particular location for the use, and if that's the case, there is no need for the brewery, so item 2B is knocked out. can the planning board still issue the permit on the strength of A through K?
I do think they can, because they're factors and they're not elements, as I said.
So knocking out B doesn't take you off the playing field. So the next question is there enough evidence on the record and the findings of the planning board to indicate that this permit still should be granted even without a showing of B?
Oh, absolutely. There was, if you go through the the planning board's hearing, you'll see that they analyzed every single element specifically, and that there was ample evidence on most of these other factors. Like I say, this need.
So can we make that call? Sometimes on criminal cases we say, oh, there was a mistake here, but there was so much overwhelming evidence over here that we're still going to affirm the result. On the record here, can we say there was a mistake, wrong approach taken on B, but even if we considered B to be a total loser, there's so much evidence to the contrary, we would still affirm it?
I think we can, because
We can't do that in a zoning case because we can't substitute our judgment for the board. The board makes the decision, and if they use the wrong test, it needs a remand, doesn't it?
well, respectfully, we're not substituting our judgment for that of the board. The board made its judgment on all these other factors.
Using the wrong test.
But under your hypothetical, the wrong test is only related to the need
Correct.
factor. All the other factors aren't even being challenged here.
Counsel, can I just jump in on that point? Suppose we decide that factor B, need, is required to be satisfied. And suppose we take a broader view of the need, not just the owner's need, but the need of the community. Is it your view that there's sufficient evidence in the record here before us today to support the board's determination as is, or do we have to remand it?
Well, there's definitely a lot of evidence in the record to the effect that that there aren't very many business uses in the town, and that they were eager to have a new business use in the town because they needed it for their town's sake. So I think if you look at the record, I think it is difficult, though, to take Justice Connor's point, that to start making that kind of a finding here now. All I'm saying is that even if you took B out of the equation entirely, all the other 15 factors were found explicitly and aren't even challenged here. So it's not like we're substituting our judgment for anyone's judgment. It's been accepted that all other 15 factors are satisfied.
Well, let me cite how other places have defined similar language and ask you whether that could make sense to you. The phrase has been construed to mean expedient or reasonably convenient to the public welfare. Cite, cite, cite. A use does not necessarily meet this standard merely because it is a legitimate one or one that is commercially expedient to the applicant. Instead, the applicant must demonstrate that the community will derive at least some benefit from the proposed use. So we need to remand saying, if we applied this test, you will need to analyze, and you need to do it, board, whether the community will derive at least some benefit from the proposed use. Does that make sense as a standard and a definition that isn't squishy for constitutional purposes?
I think that would be one definition that would be acceptable. I don't necessarily think you need to remand on that basis. I think that there's plenty of evidence in the record that supports a finding along those lines, and we wouldn't need
Whether there's evidence in there isn't the question. If you tell the jury you have to use a preponderance and it's a reasonable doubt, you don't say, well, there was a lot of evidence, it's good enough. I mean, it's the jury that decides, and you gave them the wrong test.
I see my red light is on. I don't know
If you have an answer.
my answer to that question is you're just getting at the fundamental idea by presenting all those definitions that it's ambiguous, and we need to interpret it in a light that's favorable to the free use of property, and that it gives essentially, credence to the idea that conditional uses are generally considered compatible with surrounding uses.
Thank you. Mr. Turley, you reserve some time for rebuttal.
Can
you,
you
Your
live
Honor.
with that definition that I just gave you?
I would say that it contradicts this court's holding in Inhabitants of Cushing v. Gay, that, again, in a different statutory context, that the court said it's something more than convenience. It is something indispensable to be necessary.
Well, we can vacate here only if we decide as a matter of law that the planning board should not have considered the applicant's perspective on need or the applicant's need. And can we do that if the definition is ambiguous?
Absolutely,
words-
Your Honor. I mean, if you find it to be ambiguous, the next step, as run through in all of our briefing, is to apply canons of constructions to resolve the ambiguity. So no matter how this case is resolved, if it is resolved in a way that either remands or vacates, it'll provide guidance as to how to interpret the
Well,
word need,
your
regardless of
position,
being ambiguous.
I understand your position is there's insufficient evidence to support even the applicant's need. I understand that.
Sure.
But on the test that the board used, your position is that the board erred as a matter of law in considering the applicant's need.
Correct.
And how, if the definition of need is broad and ambiguous, and it isn't tied to either the applicant or the town, how can we say that the board isn't entitled to consider the applicant's need at all and must only consider the needs of the community?
Sure, Your Honor. As I noted, I think both, even if you were to depart a bit from the plain meaning rule and you look to the canons and you also look to the context in which this is written, the definition of necessity, the purpose, which I'll again return to, of a residential district only allowing commercial uses if they're necessary to residential development, that tells you how to resolve this ambiguity.
Well, does it? I mean, what you've posited is that they have to establish the site was in some way indispensable vis-a-vis the proposed use of the land. And I just can't even imagine what that would be.
Well, Your Honor, it may in fact be preclusive. I admit that, but rather, I mean, there's all sorts of land uses that involve some input from the land or need some amount of space from the land. I mean, this is a matter where there's nothing in the record at all. It's not they tried to show it and now we're
Yeah,
left
but if
with
you're
a question.
proposing that to be the definition, it can't be absurd. And if your proposed definition would essentially not ever permit a commercial use in the residential, which is frankly not what the ordinance says, I'm just not understanding it. So I don't understand how that could be the definition.
Sure. So classically in applying ordinances, you have the test, so to speak, of what the legal meaning of the ordinance is, and then you have a factual finding as to what meets that standard. So here, I'm simply saying they have to show something about the land and in relation to the land use that's essential. Not, it
Well,
again,
there's no
has to
land
be,
that's ever going to be an essential piece for a microbrewery, and that's aside from whether
well,
it's...
Your Honor, the drafters of the ordinance wrote it this way, and it's really not before the court the wisdom of whether or not they, to use again that idea of a spectrum, they put it on one side or the other.
Thank you.
Thank you, Your Honor.
Well, thank you, counsel, for this lively discussion. As is our usual practice, we will be taking the matter under advisement and issuing a decision in due course. As is also our usual practice, I understand, Mr. Turley, that this is your first appearance in front of this court, so we would therefore invite you and counsel back to take the greetings of the court.